Good afternoon, everyone in the room. I think we're going to get started. And good morning to those calling in from the West Coast. We have a great program today. Welcome to everybody. I'm George Constantine. I'm with the nonprofit practice group here at Venable. I've been here for a number of years now, close to 20 actually, and have always enjoyed this aspect of what we do, which is to offer these programs on a monthly basis and hit topics that we hope are of interest to those of you in the audience. On areas that your nonprofits face on a day-to-day basis. And today I think we've got a great one in terms of relevance and timeliness. It's having to do with the new rules that have been introduced by the Department of Labor on employee classification from the Fair Labor Standards Act. And we have two experts who have done some great work within the labor and employment context for a number of years for us. To my immediate left is Jennifer Brzezinski. She's a partner here at the firm and does a lot of work with a lot of you and other employers on a whole host of nonprofit legal issues involving labor and employment. And also, not just on the compliance side, but also on the dispute side, if there is litigation, EEOC actions, and that sort of thing. But Jennifer has done some great work over the years, more than 10 for us at least. And then next to Jennifer is Carl Madzenek. Carl's an associate in the practice. Again, has done a lot of work on a lot of these issues in the labor and employment world for a lot of our association and nonprofit organization clients. And I think the two of them will have a lot to offer today. Before I turn it over, in terms of our schedule, I did say monthly, but we're not going to have a presentation in December. We're going to start with a whole new set of topics starting in January, and we'll certainly be in contact with you and give you the updates as they come along. So with that, I'm turning it over to one of you. Jennifer.
All right. Thanks, George. Appreciate it. All right. Good afternoon, everyone. It's so nice to be here. Thanks for giving us the opportunity to talk to you about one of my actual favorite acts. I'm that much of a nerd. I do have a favorite statute. So Carl and I are thrilled to be here. So, today we're going to talk about the new regulations, right? They were passed in September. They're minor on the scale of changes, quite frankly. But we thought it would be beneficial for you not only to go over the new changes, but also to do a refresher. So we'll get some overall compliance tips with the Fair Labor Standards Act and some kind of interrelated issues with independent contractors, unpaid interns, volunteers. So we're going to touch on a lot today, and we need to get started so we cover it in our time. So our agenda for today is, first, like I said, we're going to provide you with an overview of the new changes, and those changes are to the salary test of the Fair Labor Standards Act. We're also going to provide you with a refresher on the job duties test. In order to be exempt from the Fair Labor Standards Act, you've got to meet that salary test as well as the job duties test. The job duties test can be fairly complicated, so we thought it would be smart to just give you a refresher on that, and Carl's going to take that portion of the presentation. We're also going to talk to you about when an employee has to be classified, when a worker has to be classified as an employee under the Fair Labor Standards Act, and when you have the option of actually classifying that worker as an independent contractor. You don't have as much wiggle room, or most employers don't have as much wiggle room as they think, so we want to go over that with you as well. And because the new salary test may result in some of you having to reclassify your currently exempt employees to non-exempt because they don't meet the new salary test, we want to go ahead and go over some compliance tips for you to make sure you're complying with the new regs, as well as maybe giving you some options to minimize the overall financial liability on your organization while still being compliant. Fifth, we're also going to identify some of those problematic areas that Carl and I see over and over again when counseling employers on the Fair Labor Standards Act. They can be very confusing and very tricky, and we'll make sure that we go over those for you today. And then finally, we're going to talk a little bit about the practical implications of these regulations on employers. So, why do we need to be concerned about complying with the Fair Labor Standards Act? Well, it's because the liability can be quite high. This has become, wage and hour class action lawsuits have really come to the forefront and have doubled in the past 10 years or so. Like I said, they're usually class action affecting a large group of employees. The Fair Labor Standards Act provides for treble damages as well as double damages and attorney's fees as well. So it can really be costly to the organization, not only in terms of financial liability, but when you're not complying or you're found to be in non-compliance, the media is going to get attention and draw, negative attention, and sometimes you can suffer reputational damage as a result of these class action lawsuits. In addition, it's difficult when you're up against a jury in these class action suits. And why is that? Because everybody on that jury has been an employee at one time. A lot of people think and feel that they have been wronged by their employer at one time or another. So we're really facing a bias against employers when you have these class action lawsuits and their jury trials. And at the end of the day, wage and hour law compliance is difficult. That's why we're here, and quite frankly, it's a good thing because it keeps us employed. So let's go just briefly an overview of the Fair Labor Standards Act. Again, I'm sure most of you are familiar with it, but I think it bears repeating. So the Fair Labor Standards Act for employees who are covered. So when I say an employee is covered by the Fair Labor Standards Act, we also refer to that employee as a non-exempt employee, right? They're not exempt from the statute. They're a covered employee. So if you are a covered employee / non-exempt employee, the Fair Labor Standards Act requires that you're paid a minimum wage, you're entitled to overtime, and your employer also has to track your hours for you. As I said, minimum wage is set by federal law. Right now, it's $7.25 an hour. But as those of you who have employees in D.C., you already know that a lot of state wage and hour laws set that minimum wage higher. $14 in D.C. as of now, set to go higher in July of 2020 next year. The Fair Labor Standards Act also provides that if your non-exempt employee works more than 40 hours in a work week, he or she is entitled to time and 1/2 of their regular rate of pay. Again, not all employees are entitled to these protections. If they fall into one of the exemptions, the Fair Labor Standards Act is not going to apply to them. However, as I mentioned at the outset, in order to be exempt and not be covered by the Fair Labor Standards Act, you have to meet both the salary test and the job duties test. It's not an either or. I get that question a lot. You have to meet both. So let's talk about the current requirements, right? So we're not dealing with the new regulations now. The good news is we have until January 1st of 2020 to be in compliance and really become familiar about how these new regulations are going to affect our organization. So currently, in order to be exempt, an employee must be paid a salary of at least $455 per week. That's annualized to $23,660 per year. And they need to be paid that amount on a salary basis. And what that means is they are going to be paid that same salary each week, regardless of the quantity or quality of their work. So in other words, all that means is they got to be paid the same salary unless they fall into one of those narrow exceptions that allow you to deduct from their salary. And one example of those permissible deductions is if the employee is taking DC FMLA, you can deduct for that time. You can actually deduct from that exempt employee salary without destroying the exemption. So the general rule is, this is the premise that we start with, if an employee, an exempt employee, is ready, willing, and able to work, he or she must be paid their full salary. So let's say we're going to get that weather that they're calling for. Let's hope not, right? The snow's coming. It causes a shutdown. You, as the employer, have to shut down your offices. You're shutting down operations for one day. That exempt employee can't work remotely. Your employee is ready, able, and willing to work. You cannot deduct from their paycheck that day's absence because they were ready, able, and willing to work. So the employees who are paid $100,000 or more, this is currently, are considered highly compensated employees. So yes, that's their salary test, $100,000, and then they have the job duties test. The job duties test is just a less stringent version of the other job duties test. Carl's going to go over those in detail, but it's just a little less stringent. They only have to meet one of the requirements of one of the job duties tests. Okay, so the new test, as I said, the regulations were released on September 24th of this year, but you have until January 1 of 2020 to worry about this. So here's the new requirements. Again, to the new salary, this is the new salary test. They have to be paid $684 per week, and that is annualized to $35,568 per year. Again, they still have to meet the salary basis test, and they still have to meet the job duties test. But that is, so there's the only change to the numbers there. Your highly compensated employees, right? Now it's $100,000, but now it's going to be moved as of January 1 to $107,432 per year. Again, simply because you have somebody that doesn't meet that new salary threshold doesn't mean that they can't meet one of the other job duties tests. It's just they're going to be subject to the more stringent job duties test. They don't get that less stringent requirement. The new changes also allow non-discretionary bonuses to be counted toward these salary thresholds, up to 10%. And the key here is non-discretionary. I know a lot of you probably pay your employees bonuses, but when we say non-discretionary, it's that the employee is guaranteed a salary if certain requirements are met, either thresholds or some kind of formula. It's guaranteed. The employer can't decide not to give it to them at the last minute. So I know a lot of you, a lot of my clients that I work with, at the end of the year, they look at the organization. They look at how the organization performed. They look at how the employee performed. They have a pot of money. They distribute it to the heads of the department, and the heads of the department decide who's going to get what. That's not going to be considered a non-discretionary bonus, so that cannot count toward the new salary threshold. So an employee who no longer meets this new salary threshold of $35,568 per year is not going to be exempt any longer, right? They are going to automatically become exempt. The DOL estimates that approximately 1.3 million employees will have to be reclassified from exempt to non-exempt because of this salary threshold change. But again, the good news is there are no changes to the job duties test. So those of you who are familiar with them, there's no change, and that's a good thing. So we just keep trekking down that path. And Carl is going to go ahead and walk us through the specific requirements of those job duties tests.
Thank you, Jen. All right. So as Jennifer mentioned, there are two major tests, both of which must be met for a particular position to be properly classified under the FLSA, properly classified as exempt under the FLSA. I'm going to go over the second test, what we commonly refer to as the duties test. And to be clear, as Jen mentioned, the new regulations do not change the duties test for any of the exemptions. But as you're reevaluating certain positions, as you're looking at classifications in light of the changes to the salary test, it's going to be important to pay attention to the duties test. Particularly as you might be shifting around certain duties or creating new positions and that sort of thing, which Jen's going to get into a little bit later. Some organizations make the mistake of thinking, well, as long as we pay this employee a salary and it meets the minimum salary threshold, we don't have to pay them overtime. But as Jen mentioned, that is simply just not the case, and that's when you can get into trouble. So you have to meet this duty test for the particular exemptions. So without further ado, let me get into it. The duties test for all white-collar exemptions is going to require that the primary duty is going to involve some type of exempt work. and the type of exempt work is going to be determined by the specific exemptions, which we'll get into in a little bit. But determining the primary duty of a position, the main duty, the most important duty, can be surprisingly difficult, particularly when you have positions that involve a number of important responsibilities. So here are some of the factors to consider when looking at what is a primary duty. You're going to want to look at how important are the exempt duties or the exempt duty of the position compared to the non-exempt duties, right? Typically, the more important the duty, the more likely it's going to be that that's the primary duty of the position. You're also going to want to look at the amount of time spent on the exempt duty versus the amount of time spent on the non-exempt duties that the position might perform. So if you have, for example, a position where more than half of the time is spent on an important duty, it's pretty likely that's going to be the primary duty of the position. Now, that said, there's no set requirement that the primary duty consist of 50% or more of time worked. You can still have a primary duty where the employee spends less than 50% of that time performing the primary duty, as long as the other factors are met. You're also going to want to look at how much of the work is free from immediate supervision and direction, right? So the less supervision, the more likely you're going to meet the primary duty test. And then lastly, you're going to want to look at the wages paid to other employees for non-exempt work. Typically speaking, employees who perform exempt work should be paid at a higher rate than employees performing non-exempt work. Otherwise, it starts to look like you have a misclassification. All right. So keep these factors in mind as we go through a few of the exemptions. These are the most common exemptions under the FLSA. These are the ones that can be the most relevant for nonprofit organizations. You have your executive exemption, administrative exemption, the two different types of professional exemptions, computer employee exemption, and the highly compensated employee exemption. And we're going to briefly go through each of these, starting with the executive exemption. So as with all white-collar exemptions, you must meet both the salary test and the duty test. The salary test is going to be the same until we get to the computer employee exemption. That's slightly different. We'll cover that a little bit later. But to meet the duty test for the executive exemption, the primary duty must be to manage the organization or some department or some subdivision of that organization, and you have to regularly direct the work of 2 or more employees, and you have to have either the authority to hire and fire, or higher management must give weight to your recommendations to hire and fire. And you have to meet all 3 of these to satisfy the duty test for the exemption. So the quintessential example here is your CEO or your executive director of a nonprofit, right? That's the easy example, because you're going to have the person, the primary duty is going to be to manage the day-to-day operations of the organization. They're going to have the power to hire and fire. They're regularly going to supervise 2, often many more employees. So that's the easy example. The harder example is, say you have a mid-level manager who's responsible for a small department, right? Let's say 2 employees. They don't have the power to hire and fire, but they do make recommendations, and higher management sometimes accepts those recommendations. That's going to be a much harder example, and assuming that you could arguably meet all 3 of these prongs, it's likely going to come down to what is the primary duty. Does this mid-level manager actually spend most of their time, or is their most important duty managing the enterprise, or do they actually perform other non-exempt work, and that non-exempt work is the primary duty? In that case, you wouldn't qualify for the exemption. Or for example, does the executive, does the mid-level manager regularly direct the work of 2 more employees, or is that something that doesn't really come into play on a regular basis? Is that something that's kind of incidental to the primary duty? Again, if that's the case, it would not qualify for the exemption. So it matters very little whether this mid-level manager has a title of manager or supervisor, the head of the department, whatever it is, if they don't meet these 3 prongs. The title is not going to make much of a difference in the analysis itself. All right. So moving on to the administrative exemption. And this is the big one. This is often the catch-all exemption that many organizations use to try to cover positions that we really want to be exempt. It's also the one that many organizations get wrong because it's not entirely intuitive. So as with all of them, you're going to have to meet both the salary test and the primary duty test. And to meet the duties test for the administrative exemption, the primary duty must be to perform office or non-manual work directly related to the management or general business operations of the organization or the organization's employees. And this is the one that gets people tripped up, the position must have the exercise of discretion and independent judgment with respect to matters of significance, right? So with respect to the first factor, it's usually the one that's easier to satisfy. The type of office work that often does qualify is going to be your finance, accounting, compliance, HR, or other types of office work on matters of substantial importance to the management of the organization. The second factor is where people get tripped up because to some extent, every position is going to have at least some level of discretion or independent judgment, right? And what most people think of as discretion and independent judgment is not necessarily going to meet the criteria set out by the Department of Labor for this exemption. So here are some of the factors to consider when looking at discretion or independent judgment. Is the employee making actual choices between 2 or more courses of conduct? Are they making those choices free from immediate direction and supervision? And by that, I don't mean that the decisions must be completely free from supervision. They can be subject to approval. They can be recommendations that higher management later considers and chooses to follow or not, as long as the employee is making choices, making decisions, and those choices are free from immediate direction or control or supervision. What you don't want to have is an employee who simply applies established procedures or manuals or concepts. That's not going to be enough to satisfy the independent judgment portion of this test, right? If somebody's just applying set procedures. So a good example of a position that often does meet this test is your HR director or higher level HR professionals. Because these types of positions tend to have the power to create and implement policies. They're going to have the discretion to interpret those policies or maybe even deviate from those policies. You might have the power to investigate and resolve issues that are important to the staff. You're going to be able to make recommendations and give advice to higher management. And all of these factors tend to go towards the higher level of independent judgment and discretion required by this test. The harder example is an administrative assistant or executive assistant. And Jen and I get this question all the time. Carl, it's the administrative assistant. It has administrative in the name, right? True, I get it, yes. But does the person actually exercise discretion on a day-to-day basis? Do they make these choices every day based on their own judgment, free from supervision? and really oftentimes, I mean, sometimes they do qualify, but oftentimes you really have to get into the weeds and figure out what does the person do on a day-to-day basis in order to determine whether or not they're exempt. Okay, so moving on to the learned professional exemption, or to the professional exemption, starting with the learned professional exemption. In addition to the salary test, you have to meet the duties test, and for the learned professional, the primary duty must be to perform work requiring advanced knowledge in a recognized field of science or learning, and that's customarily going to be acquired by a prolonged course of specialized intellectual instruction. So breaking that down, the work that's going to require advanced knowledge, it's going to be typically intellectual in nature, and it's going to require, here it is again, consistent exercise of discretion and judgment. So it's going to be the same type of analysis we just did for the administrative exemption, except it's going to be in a recognized field of science and learning. And the typical examples of recognized field of science learning is going to be medicine, accounting, engineering, law, architecture, and so forth. That's not an exhaustive list, but those are some of the common examples. With respect to the third point, typically these types of positions have advanced or specialized degrees, right? And that's what you're going to see most often. But it's not necessarily a requirement. You can meet this prong of the test by having some specialized instruction or experience within a recognized field of science and learning. And so within some combination of education and experience, you can meet this part of the test. So again, common examples are going to be your doctors, lawyers, architects, professors, that sort of thing. And again, it's not an exhaustive list. Needless to say, when you have an employee that simply works in a professional office setting, that's not going to be enough to meet this test, right? You're going to have a higher bar to meet this test for this particular exemption. Okay. So the other professional exemption is the creative professional exemption, which is very similar, with the major difference being that the primary duty must be the performance of work requiring invention, imagination, originality, and talent in a field of artistic or creative endeavor. And so you're going to have your writers, musicians, artists, that sort of thing. For nonprofits, it's going to be perhaps your web designers or graphic artists who actually create the content of, or the art of their work, right? It's not going to apply to graphic artists or web designers who simply insert or apply pre-prepared art or pre-prepared graphics. Just kind of that rote application is not going to be enough to qualify for a position that requires imagination, creativity, invention, that sort of thing. Yeah. Okay. Moving right along to the computer employee exemption. And this is one that often people get tripped up on because, well, before I get to the primary duty test, this exemption is a little unique in that you can meet it either by the salary basis test, which is the same as all of the other exemptions, or as long as you meet the minimum hourly rate, which is $27.63 per hour. And what's interesting is that the new regulations actually do not affect the hourly rate. To meet this requirement, if you're paying computer employees an hourly rate, that amount can be the same now and can be the same after the new regulations go into effect in January of next year. So that doesn't change. The other areas that trip people up with the primary duty is that this exemption is not going to apply to every employee that regularly works with computers, right? The primary duty is going to have to involve the applications of system analysis and techniques. It's going to have to involve either the design or development or modification of computer systems or programs, or perhaps the testing and creation modifications of computer programs related to operations, or some combination of those three categories outlined there. So a good example might be a computer program who actually writes the code for the programs or for the operating system, or like a software engineer who develops or tests the actual software programs. The harder example is going to be other IT professionals that you might have in-house who regularly work with computers but may not meet these three categories. So employees who work with repairing computers or hardware, typically not going to qualify for this exemption. Employees who primarily serve as like a help desk function, who work with your very basic troubleshooting, that's typically not enough to satisfy this exemption. It's really designed for a higher level of systems analysis. And then again, other employees who regularly work with computers may not necessarily fall into this exemption unless they can satisfy one of these three categories or some combination of them. Okay. Highly compensated employees. Jennifer touched on this already when she spoke about the changes between the minimum salary threshold. The primary duty test is just a modified version of what we've talked about. So in order to meet the duties test for a highly compensated employee exemption, you have to, one, be involved in office or non-manual work, and two, it's going to have to involve at least one of the duties of the other exemptions which we've already covered, right? As you remember, most or all of the exemptions have multiple prongs. If you are a highly compensated employee, you just need to meet one of them, and then you're going to be covered by this exemption. So the example that we have up here is an executive who makes $150,000 a year and regularly directs 2 employees is going to be covered even if that executive doesn't have a primary duty that involves the management of the organization. Even if that employee doesn't have the power to hire or fire or make recommendations, because they meet the directs 2 employees on a regular basis prong, and because they make $150,000 a year, they're going to be covered. So really, it's highly compensated employees are much easier to classify as exempt, because you're usually going to be able to find, not always, but usually going to be able to find at least one primary duty that they satisfy. Yes?
So in this case, we have a lot of so in this case, we can add these speakers and bonus examples.
Yeah, as long as it's non-discretionary, that's right. Yeah, it goes towards the salary threshold. Yeah, sorry. So the question was, if you pay your employees a non-discretionary bonus, does that count towards the threshold requirement for the highly compensated employees of $100,000 now and $107 plus some thousand in January? And the answer is yes, as long as that payment is non-discretionary. Okay. All right. So white-collar exemptions are not going to apply to your traditional blue-collar workers, no matter how much these workers get paid. So think of like your maintenance staff or your custodian or other similar positions. And I'm going to end on the last bullet here of this slide, which I think nicely sums up the duties test, which is that you can't rely on labels or job titles when looking at these exemptions. You really need to do a careful case-by-case assessment of the actual duties performed, whether or not those are the duties listed in the job description. Hopefully they are, but it's the actual duties performed on a day-to-day basis. And with that, I'm going to hand it over to Jen.
Okay, so let's get back to the new regs. So the purpose of the new regs really is to bring the salary threshold up to kind of reflect more current standards of earnings, right? But unfortunately, it's going to have a disproportionate impact on smaller businesses and nonprofits who are already paying their employees below that new salary threshold because they just don't have the financial resources to pay those higher salaries. And so what's going to happen as a result? What are we going to have to do? A lot of these employees, we're going to have to reclassify them from exempt to non-exempt. If those employees on a regular basis work often, more than 40 hours a week, we're going to have to pay them time and a half, right? And that's going to incur a lot of additional financial liability. There's the additional administrative burden that you're going to have, and make sure that you're tracking their hours. I'm sure most of you already have some non-exempt employees, but that's just an additional burden that's placed on the employer by this reclassification. And depending on your plans and policies, the employees' benefit entitlements may change by the result of the reclassification. If you provide only certain benefits to exempt employees, or only certain policies are applicable to exempt employees, by virtue of the reclassification, they might not be entitled to those policies. So, how are we going to prepare? There we go. So, honestly, I think that the new regs provide us all with a great opportunity to remind us to say, you know what? Let's look at our FLSA classifications. What I find is a lot of time, why is this a good idea? The reason why is a lot of times job duties morph over time. The original FLSA classification that you gave to an employee upon their hire maybe 10 years ago, right, may be different. You might even be pleasantly surprised to say, you know what? I think this employee not only meets the salary threshold, but they also meet one of these job duties tests that we were talking about today. So you can reclassify them to exempt, or maybe even vice versa. Sometimes you will find the opposite and say, oh, wait a second, I'll take a look here. Yeah, they don't meet that job duties test. They really should be classified as exempt. And then what these regulations also afford you the opportunity with is when you're changing the classifications, you can explain to the employee, this is all by virtue of these new regulations. So it's not singling things out and not highlighting any maybe non-compliance issues for the employee. So again, look at your entire workforce, not just those who don't meet the new salary threshold. Make sure that they answer a yes to all three questions. Do they meet the new salary threshold? Are they paid on a salary basis, meaning you're not making those impermissible deductions from their salary? And then 3, do they meet one of those job duties tests that Carl was talking about? Again, the answer has to be yes to all 3 in order to be exempt. So if you've got a current exempt employee who you're comfortable meets one of the job duties tests and they simply don't meet the new salary threshold, what do? Well, you can bump the salary up to $35,568 a year. And you're all thinking, well, I know that, Jennifer. I wouldn't be sitting here. So the other option is to go ahead and classify them as non-exempt. And we'll spend some time talking about that, because you really do have some options and flexibility if you don't want to bump the salary up and you do want to reclassify to non-exempt. And we're going to talk about managing some of those financial implications with the reclassification. So if you reclassify to non-exempt, you can simply keep the employee's regular hourly rate, right? That's based on their current salary. You can pay them on an hourly basis, have them track the hours, and any hours worked over 40, they get time and a half. That's pretty simple, right? However, some of those employees, those exempt employees, current exempt employees, which are now going to be non-exempt, might work over 40 hours a lot in each work week. So you may want to consider converting their hourly rate to the, converting their hourly rate to the equivalent of their salary, right? So I'm going to give you some formulas if you want to write these down. So if you want to go ahead and convert the current hourly rate, convert the employee's salary to the equivalent hourly rate, all you need to do is, 1, figure out how many hours a week the employee works on a regular basis. You can talk to the employee, talk to the supervisors. How much time is the employee really putting into this? If the employee works fewer than 40 hours a week, all you need to do is divide their current salary by that number, and that's going to be their new hourly rate, right? And then you're not going to incur any additional financial liability. Now, if they work more than 40 hours a week, the calculation's slightly different. The hourly rate is going to be the salary divided by 40 plus the number of overtime hours worked in a work week times 1.5, and that's their new hourly rate. This will reduce the financial liability and hopefully not have any financial liability at all, provided you calculated and estimated the hours worked on properly. But a lot of times employees don't understand what's really going on, and they feel like they're being paid less for doing the same amount of work. So sometimes from the employee relations perspective, converting that hourly rate isn't always particularly helpful. And you do have those employee relations issues to manage when you're dealing with this reclassification issue. So another option that you can choose is to pay your employees a fixed salary, and then you just pay overtime for any hours worked over 40. So it very much works like it is now. So your non-exempt employee is going to be paid the same salary every single week for all hours worked up until 40. So if they work 20 hours a week, they're going to be paid the same amount. If they work 40 hours a week, they're going to be paid the same amount. But if they work more than 40, then you're going to have to pay them overtime. That's the fixed salary plus overtime. There are a lot of options that you have when it comes to these salary non-exempt employees. All of them require a written agreement and between you and the employee, and I'm not talking about a formal agreement, but we need to make sure that everybody's on the same page and the employee understands. One of those options is called the fluctuating work week. It's when the employee's work week actually fluctuates from week to week. You essentially say to them, we're going to pay you a fixed salary for all hours worked in a work week, including those over 40. So you're going to pay flat salary, straight rate for all hours worked in a work week, okay? But for any hours worked over 40, you're only going to have to pay half time, because the fixed salary represents payment for all hours worked in the work week. That's the fluctuating work week. Again, it has to go up and down. And the Department of Labor actually issued a new proposed rulemaking on this issue as to whether bonuses can be calculated into the fluctuating work week calculations, because there's a disagreement in the court system with regard to that. But the problem with the fluctuating work week, and quite frankly, a lot of my clients opt not to use it, because the hours change, right? Because it's fluctuating, right? The hours worked, the regular rate of pay is going to fluctuate each week. So you have to calculate it each week based upon the fluctuating work week and depending on the hours worked. So it becomes very administratively burdensome for employers to do, especially smaller employers. Okay. So now so we were talked about kind of some of these different compensation structures that you may want to consider when you're doing the reclassification, but you decide on the compensation structure and you're reclassifying to non-exempt employees, right? So you're still going to have this potential overtime liability regardless of whatever compensation structure you're going to opt. So what you can do, though, is manage the employee's overtime that's actually worked. So what I tell clients is, first thing we should do is, in your handbook, have a policy that says, hey, employee, if you're non-exempt, if you're going to work more than 40 hours in a work week, you need prior written approval from your supervisor, right? Then you have a written policy. Now, if the employee doesn't listen to you and still works the overtime, the downside is you have to pay them anyway. The upside is you can discipline them and say, this isn't permissible. You can even terminate them right for it. But again, it only usually takes one time to say, listen, this is a violation of policy. You get a written warning because you're disobeying our policy. You also want to make sure that non-exempt employees are tracking their time properly. Make sure they're accounting for lunch breaks and personal errands, right? Not those short breaks, but the longer breaks. They're running out to, go run a personal errand across the street, and it's taking 45 minutes to do so. Make sure they're clocking in and out properly. Make sure they're not just simply putting 8 hours worked or 7.5 hours worked for every single day, and the manager's signing off. This also, implementing these policies and managing overtime really should include a training of your managers, right? They're your first lines. They're overseeing the employees. They should understand what the policy is. They should make sure that their non-exempt employees are not working outside their regularly scheduled hours, and that they're not asking them to do assignments outside their regularly scheduled hours. Because if an employee works their full workday, whatever, 7.5, 8 hours, and then the supervisor tells them to go home and finish a project in the evening, and they're doing it, at their computer remotely, and they work an hour and a half, it's compensable time, and we got to pay them for that. So again, just train your managers. I also think managers should be signing off and reviewing those timesheets. So the employee is responsible for recording the time, but the managers should be looking at those timesheets as well. Yeah, so you want to be careful of de minimis time. I'm sorry, de minimis time is okay, right? That's non-compensable. That means that's just not significant enough to be compensable, but I think you walk a very, very fine line when you do that. So I would discourage all employees, non-exempt employees, for not checking emails or not having to be available, because you're really getting into a very, very gray area. So you really want to, and I know a lot of my clients are having, their systems on the employees' personal phones. And, that is all compensable time. Number one, it should be recorded if they're checking emails and spending time. I mean, how many times do we do it, right? On a Saturday morning, I'm there typing out something, 10 minutes here, 15 minutes there. It adds up. So you should definitely watch, the checking of the emails. And in my opinion, I think it should be discouraged, because the de minimis time is only going to get you so far. And then again, like I said, just remember, if they work the overtime, even if it's in violation of your policy, you still have to pay them for it. Okay. So we talked a little bit about the managing the overtime, and we talked about the reclassification, but I do think there's some other things that you may want to consider when you're looking at the effects of the new regulation on your organization. Is there a way that you look at your whole workforce, look at the job duties and assignments? Does it make sense to do some job restructuring at this point? Does it make sense to look at two employees? Let's say they're both being reclassified as non-exempt. Does it make sense to split the work such that they're not going to work more than 40 hours a week? There may be a possibility to do that. A less popular option would be maybe take some of the, some duties and move them from a non-exempt employee to an exempt employee. Probably not going to be particularly popular with that employee who's getting more work, especially if you're not paying them for it. But that's one other option. So you can look at kind of the restructuring of the job duties. You could even think about reducing the number of hours, some employees work per week, and adjusting their work week so they're not going to incur that overtime. Maybe you have a new situation in place where your non-exempt employee is not attending those trade conferences, right, that are 2 or 3 days, and they're working around the clock and incurring that tremendous amount of overtime. That might be one way to do it. You also want to take a look at your current policies. Again, another great opportunity to look at the policies, make sure they're up to date. The overtime policy, do we want to add something in there that says prior written approval before working overtime, right? Look at your telework policy. Does your telework policy only apply to exempt employees? Right? A lot of employers' policies are only applicable to exempt employees. So do you need to tweak that in light of these reclassifications? Look at your paid leave. Is the paid leave entitlement going to be changed because of the classification. Most employers don't distinguish as much on the exempt, non-exempt classification, but it's possible. And any changes you make to these, an employee's FLSA classification, their job duties, the compensation structure, communicate it to the employee in writing. I can't stress that enough. After you make your decision, the first thing, if you call Carl or myself for an issue in the future, the first thing we'll say, well, what did you give them when you changed this new structure? What did you do when you gave them these new job duties? A lot of times, oh, well, we forgot to do that. So just a little reminder there. And I'm going to discuss in a little more detail in the next section. But for those of you who are thinking, all right, well, okay, I've got to reclassify this employee to non-exempt, and they work a lot of overtime, so I know I'll just hire an unpaid intern. Or my employee's so nice, they're just going to volunteer to do the work that's more than 40 hours in a work week, and I don't have to pay them. Or even better, I know what I'll do. The Fair Labor Standards Act doesn't apply to independent contractors, so I'll just reclassify that employee as an independent contractor. The answer is no, sorry. Or highly, highly, highly unlikely. I'm going to, again, address that in the next section. So Carl and I, over our years of practice, have identified some areas that tend to be repeatedly problematic for employers. And some of these might be very obvious to you, but if they're not, it bears repeating. So a couple of misconceptions when it comes to when you're making your FLSA classifications. And Carl has gone over some of these, but I like this bulleted list. So the first one is not all salaried employees are exempt, right? You got to meet that job duties test over and over again. I hear, oh, but we are paying them a salary. Well, what do? Oh, they're an administrative assistant and they write letters and update our database. They're going to be non-exempt, right? Remember that some exempt employees can be hourly, right? And that Carl mentioned earlier, the computer employee exemption, right? They can be paid $27 an hour and 63 cents and still be exempt. Again, don't assume that the title will entitle an employee to an exempt classification. If the Department of Labor comes knocking at your door, and I truly hope they do not, they're not going to look at the job title. They will look at the job description, but they're not going to care about the job title. So just because it says manager in the job title or director or even senior director, it doesn't have any bearing on whether that employee is properly classified as exempt. So just keep that in the back of your mind. Again, Carl mentioned it, but it bears repeating because we hear it so many times. Most administrative positions do not exercise the requisite level of discretion and independent judgment over matters of significance in order to meet the job duties test for the administrative exemption. It just is. If that administrative employee is following established procedures or manuals, or it's kind of routine, clerical work, that is not going to be discretion or independent judgment in the eyes of the Department of Labor. So we just need to keep that in mind. I mean, the Department of Labor's definition of discretion and independent judgment is very, very different from a layperson's. Not all employees who work with computers, just because they touch a computer, just because you call them to fix your computer, doesn't mean they're necessarily going to be exempt. And most times, almost all cases, that the help desk folks, the first ones you call, your first line of defense, the ones who tell you to turn the computer off and then turn it back on, they're probably going to be non-exempt. And remember, you have to pay for overtime even if it's unauthorized and not, and it's in violation of your policy. Okay, so I said before, some of you had that bright idea, right? Well, I have an employee and I'm just going to reclassify them as an independent contractor. That's great. I don't have to worry about employee benefits. I don't have to worry about overtime because we're just going to agree to that rate. Okay, please beware of this classification. And just because everybody else is using independent contractors in your industry or in your type of association doesn't mean that it's right. You have to start from the premise that most workers are going to be employees and covered by the Fair Labor Standards Act unless you can meet a particular balancing test. The Department of Labor uses an economic realities test right now. It's a balancing test. It's not a bright line test. So it is definitely a gray area. But and there are various tests for independent contractors depending on the state and depending on the statute, because the IRS also has a test for independent contractor classification as well. But the common theme among all of the tests is the amount of control the hiring entity is placing on the worker. Are they directing where the work has to be performed? Are they directing how the work has to be performed? Are they supervising every aspect of it? Is the worker hired for an indefinite period of time? Or are they hired for a specific project that it comes to an end? A lot of times I will see independent contractor agreements that are for a year, but then they've been upped 6 years in a row. So it's an independent contractor for 6 years. Now that's an employee. So you also have to look at, really now the test is that independent contractor in business for him or herself? That's really what they want to look at. That's really the traditional model that they're looking at now. And regardless of whether the worker comes to you and says, I really want to be an independent contractor, that's not going to have any bearing on how you classify the individual as an employee or as an independent contractor. So just keep that in the back of the mind, because a lot of times it's like, well, we have this agreement. We both agree that they should be an independent contractor, and it doesn't matter to the agencies that are actually going to be enforcing the statute. And the reason why we care about misclassification is, as I mentioned earlier, we have to be concerned not only about the Department of Labor from the wage and hour perspective, but we also have to be concerned about the IRS. There's tax liability for taxes that should have been withheld. There's contributions for unemployment insurance and workers' comp, overtime wage liability, state unemployment insurance payments, and also employee entitlements to benefits. So the idea would be, if you have somebody, my example that I gave, right, the 6-year independent contractor who's really should have been an employee, they can come back and say, well, you provided all of your employees with this paid leave, over all this period of time. I should have been entitled to that. I should have been entitled to health insurance. So you want to be careful of that. So we also have, somebody else probably also has really lovely employees who say, you know what, I really love this organization and I love the mission. I'm fine with volunteering my time. I don't want you to pay me for any hours worked over 40. Just pay me my fixed salary and don't bother paying me time and a half. Now, a bona fide volunteer is a recognized exemption from the Fair Labor Standards Act coverage. But as a general rule, an employee cannot volunteer to perform the same services for their employer that they do on a regular basis. So if you have an employee who, let's say you're a nonprofit hospital and it's a nurse, and part of his or her duties are to take, blood pressure or take blood, they can't volunteer to do those same duties over 40 hours in a work week.
Something at the same organization that's very different from what they would normally do? So somebody normally works in an office with volunteers to coach a basketball game. That would be considered voluntary?
That probably would be okay. I mean, I think that the good rule is when you have volunteers, it really shouldn't be integral to your business. Like it should not, right? So it's something that has a charitable or humanitarian purpose. So a Department of Labor opinion letters out there, I think it was somebody who performed some kind of janitorial services for the organization. Also, I believe, was able to volunteer with the children because it didn't have anything to do with his duties. I think so. Anyway. So anyway, you do want to be, so make sure it has a charitable humanitarian purpose before you do that. And when it comes to your own employees, volunteering for your organization, it's really better to pull from the general public. If you want to post to the general public to volunteer for a charitable purpose, that would be okay. And if your employee signs up, that's okay, but you would want to have a wider band. That's a safer route to go, because you don't want it to look like that the employee's being coerced into volunteering, and thus thinking that they would have to be paid for it. Okay, so I mentioned definitely make sure you reduce any changes to job duties and assignments and compensation structure and FLSA classification to writing, right? It prevents confusion. But in that really is also look at your job descriptions. Like I said, the Department of Labor is not going to look at your employee's job title, but they will start with your job description. So you want to make sure you have an accurate job description for your employee, not only for the Department of Labor, to show that, oh yes, this employee is properly exempt because he or she, exercises independent discretion or judgment, but it also is what you need in order to show that the employee is meeting performance expectations, right? Because often when Carl and I are counseling on maybe disciplining or separating an employee, there's confusion because the employer hasn't properly communicated to the employee what their job duties actually are, right? And that can present some issues. So look at those job descriptions. I think a really great time to do it is performance evaluation time. You can do it on a yearly basis. You will be amazed at how job duties morph over the course of the year. Have supervisors really focus and make that part of it. Have that be part of the discussion point. Talk to the employee and change those job descriptions. Make sure everything is make sure that's all classified properly. And one final thought before we turn it over to questions is comp time. So some of you may be saying, I know, I won't pay my non-exempt employees time and 1/2. I will just give them comp time that you can use on another day for it, right? I'll just put it in a paid leave, but I'll just put it in a leave balance, and I don't have to pay them for it. It's not permissible. So government employers are allowed to provide their non-exempt employees with comp time in lieu of cash payment, but it's not permissible in the private sector, including for nonprofits. So you can't avoid the 40 hours on a work week by giving them the comp time. You can do it for your exempt employees, provided they meet certain requirements, meaning they're still making that same salary and their bulk of their compensation isn't coming from the comp time. But I would call it something different than comp time, because I think employees get very confused when you use that term, and really that's really a better place. That phrase has a better place in the public sector. So with that, we'll turn it over to questions. Yes.
So on your last point about the comp time,
yes,
awarding an exempt employee's additional may be acceptable. So we could utilize the efforts of comp time, just call it something different.
Yes, for exempt employees.
Yes.
You can't use it for non-exempt. Yes. Yes, you could do that. It's like a bonus time. It's actually in the regs specifically. You can give them additional leave for it. But I would make sure, if you're going to do that, I would make sure that you have very clear, specific parameters around it. Because it's going to be treated like a paid leave then, right? You have to talk about, does it have to be used within a certain time? Are you going to pay it out upon separation? All of that good stuff. So I would, if you're going, I know that some employers have kind of a loose comp time thing. But if you're going to have a more formal comp time policy, reduce it to writing so people are doing it consistently. But if you have one of those situations where every once in a while an exempt employee works crazy hours over the course of a weekend because of the conference, and the employer says, oh, you don't have to come in on Monday. That's okay. That's not real comp time.
We have it very spelled out. Qualifications.
Good. Great. Great. And the last line should be non-exempt employees are not entitled to comp time. Yes.
You mentioned that exempt employees can be paid
For the computer professionals.
oh, just
Yes. You can, yes. I mean, just because somebody meets the exempt classification doesn't mean you need to treat them as an exempt employee, right? You can still treat somebody who meets both the salary test and the job duties test and treat them as a non-exempt employee if you want to.
Jennifer, how many hours does an exempt employee have to work before their PTO kicks in?
I think, well, a couple of things. When you're looking at exempt employees, the Department of Labor, or even non-exempt employees, well, non-exempt employees they do, but exempt employees, they're not going to look at the number of hours worked in a work week. You can work it, I think I'm not understanding your question 100%. So,
Say, for instance, there's an 8-hour day in the work day, and I only work 2 hours. Does PTO have to be kicked in, or because I'm a professional, do I have to come up with policy identifying specifically what that hour criteria is?
okay, I appreciate the clarification. So yeah, I think it really depends on your workforce. I have seen some clients who will say, you know what, if an exempt employee takes more than 4 hours off at a time, they have to use PTO. Or they will say if they use an increment of 2 hours or 1 hour, you have to use PTO.
So it's not law-driven. That's a decision based on everyone's.
Exactly. At the end of the day, what I've seen happen is sometimes there, unfortunately, occasionally an exempt employee who will try to take advantage of the situation. And you're kind of left with them only working part days and not doing their job. And then it becomes a performance issue. You can say, and we have this in some of our handbooks, all employees, including exempt employees, are supposed to work regular hours of, 8:30 to 5. And, non-exempt employees are expected to work as much more or as much as expected to get the job done, right? Because that's what the salary stands for. But it's not hours driven. Does that answer your question?
I have a question. Can an employee work, I'm going to give an example of just a generalization, work as I'm just going to use tailor as if it's a exempt position. Work 40 hours as a tailor, right? As if it's an exempt position. And then in the afternoon, work an on-call schedule and not be paid time and a half if they're available to work there.
I think what you have to look at is what their primary duty is going to be. The Department of Labor is going to look at it all together. So it really is going to be what their primary duty is and whether they meet that.
The duty is the same. They're just working on an on-call schedule. So the duty is the same. They tailor in the first 8 hours, and then they're available in the afternoon, working another 4 hours as a tailor, but it's on an on-call basis.
On an on-call basis.
So would they be paid just straight time? Would that be considered a secondary job? Would it be straight time? Or would time be time and a half?
They're going to look at it. The Department of Labor is going to look at the whole work week. Some states will look at it on a day-by-day basis, like California. But the on-call time for non-exempt employees, the rules.
This is an exempt employee. I'm just using that title as an example.
Oh, I see what you're saying. Okay. Well, with exempt employees, it doesn't matter how many hours they work. They're going to be paid the same salary regardless of how many hours they work, if they're exempt.
Yeah, they're exempt and they're working 40 hours a week as a tailor.
Yep.
And then in the afternoon for the same job, they're being paid additional pay, at the flat rate of their salary position. So my question is, and I'm basing this on the salary and plus the time that you just described here, the new rules.
Yeah. Well, that's an exempt. That's a non-exempt employee. We're talking about the six.
They're an exempt employee, but they're getting paid extra hours for being on call. They're getting paid getting paid extra money. They're a salary employee during the week, but then in the afternoons they work on an on-call basis, and so they're being paid additional funding.
Okay.
So my question is, would that be straight money, straight hourly rate, or would that be time and a half?
Okay.
And again, I'm basing it on what you had just described with the salary plus the time.
I think if that person is paid salary.
So it's considered two separate positions. One is an on-call position, and one is a salary position. I understand what you're all saying, but what I'm saying.
Yes.
And gets paid per hour of work. Again, it depends on who the auditor is, the investigator is at wage an hour. But especially in the district, we've seen some of that sort of big picture, which is why it's always good to think about, okay, here's my exempt employees, and here's my non-exempt employees. Here's what I do with my non-exempts. How many of those things I'm also doing with my exempts to make it so that if I have someone that's on the edge a little bit that we're really worried about, and you have to look at that totality, where's the balance?
Sorry. Karen Pass, one of my partners.
It's like she's really knowledgeable.
Yes, ma'am. Yes.
What if it's an agency, but you could use the same person?
Oh, that's a great.
Just the agency issue, or do you do it?
Well, I mean, from the tax liability, it's not, you're not going to have as much concern, right? Because they're an employee of the agency, correct? But yeah, you're absolutely right. I think to us, probably once you start getting over that 6-month mark, you start to worry, this really looks more like an employee, and it becomes a benefits issue, right? Whether that temp employee is entitled to benefits. So if you can't, when your temp comes in, you can have them on for a particular period of time, but then I would have internal mechanisms in place to say once that project's over, right, they're moving on, and or if it gets to that 6-month mark, it becomes. Yeah, that would be one way, absolutely around it. And I have had clients say, oh, well, it's going to be a temp employee because we have funding for 2 years, and then the funding's going to end after 2 years. But that when you have somebody who's there for that long, it really starts to look like a permanent employee as opposed to a temporary employee. So that's something definitely to be conscious of. Great question.
Can you give us some guidance on non-exempt employees being on call? For example, we have our IT help desk. They're on call. They're all non-exempt. And they're on call
Yeah, I mean, the rules are pretty specialized. I will tell you as a general rule, when you have on-call time, the employee really has to be free to do what they want to do, leave the premises, be able to use their time as they see fit.
And they are. They're at home, and they're only called into action if they're called. Mm-hmm. But they're free to travel, and they just have to be able to answer the call.
Yeah.
If they're called.
I mean, generally, I would think that probably wouldn't be compensable time, but subject to the caveat that it is really factually specific and driven. But, yeah.
We may need to talk after.
Okay.
You're paying a lot of money, and they're never getting called.
And you're paying them.
Like the whole weekend.
But do they have to be next to their computers the whole time? Or are they free to?
They all have phones, iPhones, and it's.
Okay. Anyone else? Oh. Gotcha.
Articles are off the website, and that's what this person does. Is that a job?
Potentially, yeah. I mean, if their primary duty is to actually create content, actually write articles or whatnot, it could potentially be. It would really just depend on what the primary duty was. They spend most of their time doing this. Is this what their most important duty is? Potentially, yes.
I mean, kind of as a follow-up to that, I mean, you really have it's under the professional exemption, right? So it has to be, they have to have that degree of advanced knowledge and learning. So a lot of those writing positions, they're probably not going to meet that high a threshold. When you think about, you're talking, I mean, it's a pretty high bar. So you want to think more of artistic. So your web designer, maybe, if they're actually creating something, your graphic artists, not those that are like inputting clip art, but those are actually creating graphics, that would probably fall under the creative professional exception.
Just a quick recap. You're saying that in order for you to be an exempt employee, from a perspective that you're an executive, you only have to meet one of the criteria. All the other exempt professionals have to meet 3.
So highly compensated employees. So highly compensated. So it's 100,000 now, and if it's going to be 107 plus beginning Jan 1. So that's the highly compensated salary threshold test. There's also the job duties test. So you'll look at one of the job duties tests that Carl went over, whether it's executive, administrative, or professional. And that employee of the one job duties, let's say it's the executive, they only need to meet one requirement of that job duties test. They don't need to meet the full, more robust test. Does that help? Okay.
So when we're auditing, as you mentioned, auditing your position descriptions, which I think is important. So from an HR standpoint, we can't always audit it. It has to be kind of the manager, correct? That kind of looks, because they really know what those everyday duties look like. Me, from an HR standpoint, I could say exempt versus non-exempt, but that manager really is the person that knows what those responsibilities look like, correct or not?
Yeah, I agree. It should be a collective effort. I mean, that said, you want to make sure you're doing your audit, kind of at a low key scale, right? We don't want to raise too many questions in the potential event we have a misclassification somewhere. So you can do it in that's why I like the new regs coming out, because it gives you that opportunity to say, listen, we're looking at it, and then, sit down with your managers and talk about it, take that job description, dust it off, some of them, 5+ years old, and say, is this really what they're doing? And particularly in light of you that have funding and there's different stages of the projects and things like that, I really see job duties morph over time. So it should be collective, but I agree with you. We do it as part of our corporate due diligence sometimes on deals, and you're supposed to look at this employee spreadsheet, and you look at these titles, and you're supposed to classify them as see if they're properly classified based on job duties titles. Based on job titles as opposed to what they're actually doing. So work with your managers then, definitely. That's a great idea.
Is everybody as a teacher
Right.
So, well, under salary basis, most states also, but there are some states that say, but it's about it. Yes, coaches.
That's another complicated kind of question. It's like, so the executive exemptions is pretty specific, kind of demanding. But my experience, like a lot of folks who might be a hard case on the executive side could usually fit under an administrative exemption.
Yep.
Like, is that sort of your experience? If that is the case, is there any reason that we would fight to fit someone under an executive classification when we pretty easily?
Well, to me, I would go with the classifications that's most obvious. But you don't have to tell the employee. You just tell the employee whether they're exempt or not exempt. You don't have to give them the rationale. But internally, I would probably go with the one that's the most black and white, right? But there is no reason why somebody who's an executive also couldn't fit into the administrative exemption. And quite frankly, with your computer employees, those who touch the help desk, a lot of times they might not need the computer employee exemption, but they may meet the administrative exemption depending on exactly what they're doing. So it's definitely something to, to think about and to consider.
It's not all that unusual that you have somebody at the higher level that uses a lot of independent discretion and judgment that fits into multiple categories. So in the end, the result's the same. As long as they fit into one, they're going to be exempt. As long as they fit into one exemption and they meet all of the requirements under that exemption. What? Well, so remember, for highly compensated, you have to have the salary, and you still have to meet at least one prong of one of the other exemptions, right?
If they don't meet one of the other, it's just that they're highly compensated.
Right, as long as they meet. No, if they're highly compensated, right, if they make more than $107,000 come January, and they meet at least one prong of the primary duty test for one of the exemptions, they're going to be exempt. They're going to be fine.
And if they don't meet that,
Then they're not. You can't just get 150 or whatever it is and just be exempt. You still have to meet a modified version of the duties test.
Duties test, exactly. All right. I think that's it. All right. Well, thank you so much, everyone. Really appreciate it. Appreciate your time. Thanks for coming out on this.